Hello, nice people. Today is a day, I forgot what day. What day is today?
Monday.
Monday? Monday. Okay.
August 1st.
Okay, great. Oh, August. How did it become August? Jeannie, your run as president is half over. How did that happen?
Almost done. I have no idea.
Wow. Wow. So that actually is a great segue. My name is Dan Hershkowitz. I am proud to say that I have been a member of SFAR for 20 years. I've been on the board for 6 years. I was the president of SFAR last year. And the best thing you can be is a past president. And so we have on this screen the current president, Jeannie Gant. Hi, Jeannie.
Hi there. Hi, everyone.
Jeannie Gant of Gant Properties. A lot of you know her, of course, from her sales over the years, but she is our president. And in keeping with our Christmas story theme, we have the current, the past, and we have president of the future, Damon Knox. Hi, Damon.
Morning, Dan. Hello, everybody. Good to see everyone on a Monday morning.
Good. Great to see you. Damon, you were with that company called Zephyr for a long time, and now what are they called?
Correct. Corcoran Global Living.
Nice. And Damon, of course, works and practices here in San Francisco, but also has a real knowledge of the North Bay. And so that's a little secret for those of you who need a little North Bay advice in the future. Yes. Okay, so today we're doing, I did not know that. And I think this is session 3 or 4 or something. And let's jump right into it. Emily, if you could help us, and Emily Harold is with us. She is our director of information. What do we actually call it, Emily?
You could say marketing and communications.
Thank you. Communications is the word that I was looking for. I ended up with information, communications. And so thank you very much, Emily, for driving the train today and creating these slides. All right, what did the people want to know about? Let's find out, starting with.
1 second, Dan.
Okay.
So question 1 for Dan. All
That's
right,
me.
and I believe, so I have the slides here. How do you opt out of Zestimate, Dan?
Okay, so here's what's great about this question. I had to go look this up. And where did I go look this up? Well, I contacted our own MLS. And here's what's funny. Jeannie and Damon have been on the MLS committee forever, and I think both of you have chaired it. So you probably knew this. So the one who's saying today, I did not know that, is me. And so if we go to the next slide, we'll find out what I did not know. And it turns out there's a button, right? So you know how there's a button that you can turn on and off VOW and IDX feeds, right? And who gets all of this information? Well, it turns out there's a button to turn off the automated valuation method, the AVM. I'm not sure actually if the M is method, but it's called the AVM, and I'm pretty sure A and V are automated valuation. And so literally there's a button and you can turn it off, and that ends it. And so I put this on Facebook, and we had a big Facebook discussion. And I think that in the end, 90% of the time, this actually works. That's what it seemed like. Okay. Damon or Jeannie, you want to add anything to that?
I think it's pretty self-explanatory. One of the great things about this is it literally is us telling our third-party vendors not to issue the thing that they have normally set up as a field in their data output. And if we're telling them no, they should abide by that to live up to the data agreements that we have with them. So this is very true. Every time I've clicked AVM no, it has in fact worked for me anecdotally. But we do have a staff of wonderful support at MLS that are following up on this on a regular basis, just to make sure the compliance is there as well. So if you have a problem with this in the future, just support at MLS at MLS at SFARrealtors.com.
Let's do that one more time. MLS for multiple listing service at
SFRealtors.com.
Right. Okay, cool. All right, next one, please, Emily.
Dan, this is a question I have for you.
Good.
How do you remain neutral and agnostic in real estate dealings?
And I guess the other question is, why does it matter, right? And so here's what generated this discussion. We often have clients who are let's put it this way, their expectations are a little bit over the top. And what we need to make sure we do is that we make sure that their expectations are based on data and the market. And sometimes these people are unwilling to take responsibility for making decisions and their own actions. And so what's really helpful is that we watch our pronouns and that we remain neutral. We don't create the facts, but we do have access to the facts that our clients don't, like the market data, right? We run comps for a reason, and we need to show them the comps. We need to show them why this property compares positively and negatively to their property, how they can make their property more like this, what they can do to maximize their value. We need to try to do our best to quantify that, show them the comps, have them confirm that they've seen it, and perhaps give them a range and say that given today's market and the condition of the home, the range is this. If we do this, I'm assuming the market stays the same, the range will probably be this. Please confirm that you understand and that you've seen and read these comps. What's interesting here is that our pronouns often undermine this neutrality. And let me make sure you understand that. So let's go to the next slide. And when I talk about our pronouns, what I'm talking about is the use of we and my and I. Those are the wrong pronouns. The right pronouns are, in fact, avoiding the pronouns and substituting the we and the my and the I with the buyer and the seller, right? And you have asked for the following, right? So the buyer has requested the following. The seller responded as follows, right? There isn't an I in the we. And when you do that, it makes this process a lot easier for you. And it ends up making the client take responsibility for their own actions. So this is particularly helpful when it is dual agency. Imagine you represent both the buyer and the seller, and you're using the we pronoun to describe you and the seller. Well, your buyer is going to feel as though they're ganged up on. What do you mean we, right? The seller has asked for this. I am asking for that, right? What is the we? Why aren't we the we, right? And so the pronouns are important. Let's see what the next slide says. And here's some examples, right? So the seller, and here's how you should be responding. So the first one, the seller is in receipt of the offer. Seller responds with the attached counteroffer. It expires at 3 p.m. on Tuesday. We look forward to your response. Or, for instance, the third bullet point down, the seller has reviewed the buyer's proposed amendment. Seller accepts some items and rejects others per the attached seller amendment of existing agreement, number 2. Also attached, please find the buyer notice to perform, which gives the buyer until the end of business day on Thursday to remove all remaining contingencies. The idea here, and I'm curious what you have to say about it, Jeannie, is the neutrality of it. This is where we are. This is how the clients have reacted and what the clients have decided. And in this example, I throw in a notice to perform because often when we're using the we and the I pronouns, it seems personal, and serving a notice to perform somehow seems like an insult, and it shouldn't. It's all about keeping the clients and the parties in line with their contractual timelines and obligations. Why would that be personal? And when you take out the personal pronouns, it makes that process a lot easier. Jeannie, any thoughts? Am I right? Am I wrong?
Yeah, I agree. I mean, we tend to get caught up with our clients, our buyers or sellers' emotions of buying or selling. And this is a really good reminder to, step back and realize it's the seller's responsibility, it's their seller's decision or the buyer's decision. So great reminder.
Let me give you one more example, and then we'll skip forward a few slides because the next slides are really just about what I've said. Here's one more example that I think is interesting. Often we have a situation where the seller, and we're listing a property, knows the contractual timelines. So the seller has calendared either mentally or literally the 15 or 17-day investigation contingency. And they know, for instance, that here today on Saturday is day 17, right? Or today, Friday is day 17. And they say to you, have they removed the contingency? And you say, no, I just talked to the agent. They're still trying to figure out what they're going to do. And the client says to you, well, tomorrow morning, I want you to send the cancellation if they don't. And then you have to say to your client, oh, funny you should say that. I actually have to send them this thing called a notice to perform first and give them 2 days. And if I send that today, the second day is Sunday. And so that gives them until Monday, but Monday's Labor Day. So they actually have until the end of business day on Tuesday, 11:59 on Tuesday, to remove their contingencies. And your client says, today's Friday. They have until Tuesday. Why didn't you send this thing before, right? And so you literally get into that issue. And a lot of you don't send a notice to perform because you think it's somehow personal. I want you to be agnostic about this whole approach, right? Think more about the transaction and less about this I-we personality issue. All right, let's move forward several slides to the next question. Yes, keep going.
All right.
And again,
one more slide.
and one more.
Right.
Right.
So this is a really good one because I recently had to deal with this too. What's the right way to issue a credit to my buyer? Do I amend the contract?
Okay, so let me ask a rhetorical question, Ginny. If you amend the contract and your amendment says, I, Jeannie Gant, will do something, right? An amendment of the contract is an amendment of the contract between who? The buyer and the seller,
The
right?
buyer and the seller. Yep.
Right. And that same contract in there
Too many
somewhere
parts. I
says,
can't get sound. I've got video, but no
Let's
sound.
see, are you sure?
the irony, Ian, is that we do hear you. Okay, so what's funny is that contract actually says somewhere in it that the realtors are not parties to the contract, right? And so
Yes.
it would be literally ironic to have an
I've
amendment
done that before.
contract
And you know,
signed by the buyer and the seller that doesn't say they'll do anything different. It only says you're going to do something, right? And so if we switch to the next slide, you'll see that the best way to do this is
Okay.
not through the actual contract, but through your escrow instructions. You can simply amend your escrow instructions to show your $5,000 credit, your $10,000 credit. Now, you might need to talk with the lender, right, about this credit to make sure that your client, the buyer, can handle the credit, that it doesn't exceed closing costs, for instance, right? But the best way to do it is through escrow instructions, and you can then communicate to your client in any method you want, confirming. Usually an email satisfies your client. Sending them a copy of the escrow instructions that you've amended usually satisfies them. But what gets frustrating, Jeannie, and I'm sure you've been there, is when the lender says, no, we need an addendum to the contract.
Mhm.
And you're like, no, you don't. The
But
contract.
why?
Right. It isn't
Right.
between, right. And so I would start with a why. It isn't between. Here's my amended instructions. It literally will show up on the closing statement. That's what you need, right? It's
Mhm.
going through escrow. But if they can't be satisfied there, then you can pull out an addendum or an amendment form, and you can use some language such as this. And I apologize for being Compass, but of course I am Compass, so that's what I did. I apologize. I should be more neutral. Compass agent Jane Smith instructs escrow holder to issue a credit to buyer in the amount of $10,000 at close of escrow from the buy side commission. This credit shall appear on the closing statements and shall be disclosed to all parties and the lenders. I throw that out there because it's a reminder you need to disclose it to everyone. The real estate agent brokers are not a party to this purchase agreement. And you can then sign it. You can sign it anywhere you want. And if they insist the buyer and the seller sign it, well then
breakfast.
use DocuSign to change their signature merely to say received and acknowledged, because it isn't a part of their actual contract. Okay? All right.
Yep.
All right, cool.
So in my case, I was crediting myself because I'm in my own purchase. And the bank, all they wanted was escrow instructions and reflected on the statement. That's all they wanted.
Good.
So we were done.
Good, good, good. All right, what's next?
This is always an interesting one, at least as far as I'm concerned, because I do, as Dan said, have knowledge of the North Bay and live there and work outside of San Francisco. But is there a termination form other than the CAR termination form, Dan?
Well, here's what's funny about that is CIR, of course, doesn't call theirs a termination form. They use what we would expect the word to be used, which is cancellation, right? And so when you go into zip forms, for instance, and you search the word cancellation, you'll find the CAR form. But until about a year ago, you wouldn't find the equivalent SFAR form. Why? Because ours was called termination. But we switched the title inside of zip forms so that when you search the word cancellation, you'll find it. But when you actually look at the form itself, you'll see that it's called the termination form. There's a legalistic reason for that we do not need to go into today, but the San Francisco termination form is our version of the cancellation form. My preference would be that you use the San Francisco forms when available for a San Francisco purchase agreement. Until just recently, when CAR updated their cancellation form, ours had a couple of real distinct advantages. Frankly, David Perry and I were able to convince CAR to amend their cancellation form so it now looks very similar to ours and has the same features as ours. And for those of you who are paying attention, you'll see that the CAR forms every year are looking a little bit more like ours for some of these reasons. If we switch to the next slide, I want to show you that big change because it's interesting. Often we get into a situation where the buyer wants to walk away, but they may not have the right to walk away, right? And so if the buyer sends the cancellation termination form, the first thing they have to do at the top is say why they're canceling. And they want to choose some sort of mutual cancellation option, but that's not the way these forms are set up. And that's not quite the way the law works. The Cancellation Act itself is unilateral. And if you don't have a good reason for canceling, then you've done something that we call at law repudiating the contract, which is a breach. And so it gets very sticky on how you fill out the top half of that cancellation form, because it says in good faith execution of the following contingency per paragraph number, whatever. But what if you've removed all your contingencies? Or another choice is after serving the seller with a timely notice to perform, to provide whatever documents they didn't provide, and waiting 2 days, I'm now canceling. But what if they provided everything, right? So it becomes really tricky if your client really didn't have the right to cancel. But now there's a choice, section 2, and a box to check that says this is a proposed mutual cancellation. So you check that box, you say to the other side, and it can be initiated by the buyer or by the seller, right? Let's say the seller just decided they don't want to sell anymore. Can they cancel because they changed their mind? No, it's a binding contract, right? And so if the buyer has performed, right, they can be forced to sell the property. So they check this box that says mutual cancellation. And then they fill out the second section, section 2, which is what do we do with the deposit, right? And do we release each other of any further rights and obligation claims against each other? And if both parties agree, they sign that second section, and we have a cancellation based on those terms. And the deposit gets either sent back to the buyer or gets given to the seller, or some hybrid. Some of it stays with the seller and some goes back to the buyer, however they filled out that bottom section, okay? It's a mutual decision. But if they don't agree and the other side simply says, no, I'm not going to sign, then they continue on with the contract. Nobody has breached, nobody has repudiated. This is the proposed termination by mutual agreement. It's been in our termination form for a little more than a year. CAR just picked it up a few weeks ago in their latest version. Any questions on that? All right, let's go on. Ooh.
This is interesting. Is deeded parking really an exclusive easement, Dan?
So this is an issue of nomenclature, right? So we often are interested in this concept. Does it come with deeded parking, right? I mean, how many times have you heard that, Jeannie? A million, right? And you've probably said it. You probably had listed a property and you say, oh yeah, it has deeded parking. It has deeded storage. It has a roof deck deeded to this unit. It has outdoor space deeded to this unit. But what you really meant was there's an exclusive use easement. Next slide. So the reference to deeded parking is really a misnomer. The parking is almost never deeded because deeded is a separate concept. There's no separate APN, which allows the parking to be sold separately, right? So it isn't quite deeded in that way. I will give you an example of occasional deeded parking. I know somebody who owns many dozens of parking spaces at a particular mid-rise in South of Market, right? One of those 8-story mid-rises. At the time they were selling originally, they were selling to the young hipsters, and many of them no longer cared about cars. And so they were finding that, oh my God, we are not selling the parking the way we thought. And including an exclusive use parking spot with the unit didn't seem to be that big of a deal. And they hadn't assigned them yet anyway. And they were working one by one to assign them and then update the condo maps and the CC&Rs to show the exclusive use parking as they were making these deals. And so someone came in and bought 100 of them. And they now have 100 different APNs and are paying taxes as though they have 100 little parcels inside this building. That's deeded parking. What you have is an exclusive use easement. Let's go to the next slide, and I want to show you what the prelim looks like. So this is a very typical prelim, right? It shows 3 different parcels. The first parcel says it's a condominium, and it's on the parcel map, and it gives the parcel map reference. The second parcel, parcel B, says I have an undivided interest in the common area. In this case, it says 57%. What it really should say is 5.7%. There happen to be 22 units in this building. This unit is a little bigger than some of them, and therefore there's this 5.7% interest. But look at parcel C. That's our deeded parking. It isn't really deeded. It's an exclusive use easement, but that's what you're looking for when you're representing a seller to make sure that they have this thing to sell, or when you're representing a buyer to make sure your client really does have exclusive use parking, right? That is in the record and in the deeds and will pass on to the next person. And so there it is. Exclusive easement to use parking areas designated as P1 on the map, exclusive use of storage areas designated S1 on the map. And now as a good agent, what should you do? You should ask for the map. You should pull it out, make sure there really is a P1, there really is an S1, and it really is where you think it is. Because sometimes it says it, but the maps are screwed up, or when they laid down the lines, it's different than we think. And according to the maps, your client has been parking in P5 all this time, as opposed to P1, and we need to get this resolved, or at least disclose this before we move forward. Okay, any questions on that? All right, we did it.
And what's my obligation to disclose my own financial interest in a transaction?
You know, Damon, it turns out that DRE, pesky as they are interested in making sure that we're not hiding our own financial interests in transactions. They're particularly concerned that we're not deceiving the public, particularly our own agents. That, of course, would be a conflict of interest, right?
So transparency matters?
Believe it or not, it does. And so they want to be able to hold us up to the light and see what's happening. And so our code of ethics also tell us that we have this obligation, And if we look at the next slide, we'll see that the NAR Code of Ethics, Article 4, says that we have a duty to disclose potential conflicts, and we must make our status as a licensed agent known to all parties, buyer and sellers, and also to all real estate agents. And this duty applies equally if the seller is a licensee, the buyer is a licensee, we own a financial interest in the thing that's being sold, or our relative or spouse are the buyer or the seller, or our relative or spouse own a substantial interest in the entity that owns the thing. And so what does that all boil down to? Well, it all boils down to, in the MLS more remarks, perhaps in the flyers, and definitely in the additional terms, and or you're avid, you're going to have the following. Buyer is a licensed real estate agent with Compass. Agent Hershkowitz is related to the buyer. Agent Hershkowitz is related to the seller. Buyer Hershkowitz is a licensed real estate agent. Seller is a licensed real estate agent. Agent Hershkowitz is a partial owner of the property. Any of those, right? Or it could be the same with my spouse, right? Agent Hershkowitz's spouse is an owner of the property. Agent Hershkowitz's father is an owner of the property, etc. Got it? Okay. And if you did not know that, Damon, now you know.
All right, Dan, next question. What happens if only one party initials the arbitration or liquid damages clause?
Okay, so Jeannie, let me just ask you this question. I'm going to
Hold on,
ask
do
you
we
this
have a
question.
question from Amanda? She has a quick question
Yeah, sure.
before
Go
we
for it.
start. Amanda, go ahead.
Okay, can you guys hear me okay?
Yes,
Yes,
we
hi,
can.
Amanda Jones, who is also, by the way, a volunteer on your board of directors. Thank you, Amanda, for volunteering.
Oh yeah, I'm happy to. So question for you. I remember reading so let's say, two questions. You're not actually married to the person, but let's just say you call them your partner and they're involved. I feel like you should also disclose if someone's your partner or you have more than a casual relationship. I've also seen on some things that if someone has more than just a client, agent, or realtor relationship with an entity, that should be disclosed. I remember seeing it somewhere that if somebody was someone's old boss or, in some authority, or they know each other really well, something along those lines, that you have to disclose that to the buyer. And I'm just wondering if you have any clarity around that.
Let's take them one at a time. So the NAR Code of Ethics talks about a potential conflict of interest. And what you've described may be an actual conflict of interest, right? Or at very least, something that is affecting your motivations. So yes, I may not technically be married to this person, but I'm a director of risk management. And if I'm going to talk about risk and management, then I'm going to say, if I've lived with that person as my partner for the last 14 years, does it hurt to disclose it? It certainly doesn't. Will it take away an argument later that you somehow hid this from someone? Sure. But one thing I don't think you need to disclose is that, for instance, the sellers or the buyer are your close friends. Because if we didn't have close friends in a sphere of influence, we wouldn't be selling anything, right? So I really don't think that the idea that the sellers are your close friends is important here until we have dual agency, right? When we have dual agency, we have this potential for conflict that we're not talking about. I think there's an expectation from every buyer that if they are self-represented, that the listing agent is going to be doing their best, of course, for the seller. And the moment that you're also writing an offer, right, I think they need to understand, listen, there is dual agency here. There is a potential of conflict. And I'd also like you to understand that these are my close personal friends, and I've been close personal friends with them forever. I will do my best to be neutral, as I'm supposed to, but you may want to consider getting your own agent. What would you like to do? Okay? That's the practical world.
Thank
All
you,
right.
Amanda. I guess when in all doubt, it doesn't hurt to disclose, right, Dan?
Right. Yeah. And that's the risk manager in me saying, the joke is anytime somebody writes to me and says, Dan, should I disclose? I can stop reading, right? The answer is yes, you should disclose. Just by asking me the question, right? Yes, the answer is you should disclose. Rarely is the answer no, you should not.
Right.
It
And
looks
then Mila has a question.
Hi, yeah. Good morning, everybody. I was just wondering, a nuanced situation is, what if I'm working on a team and I have one person on my team list my property, and I'm not signed on the listing agreement as an additional agent? How do I handle that nuance? Is that also one of those, we'll disclose it later? The team member is the owner of the property, or is that better handled up front? And do you have verbiage for that, Dan?
So the suggestion that we had here in where to disclose is not only in the avid and theoretically in a counteroffer, but also in the MLS remarks as well. So right away, I would be doing that. And so when you're selling your own property, but you decided that you're going to have your team sell it, I want them to disclose immediately that the seller is a licensed real estate agent and a member of this team, right? Even if you're not participating personally in the actual marketing of the property. And then the other thing, Milo, that's going to be really important is that you don't represent a buyer, because that would be a real conflict of interest. I would never want you to represent a buyer in the sale of your own home, and just putting the wall between you and the buyer with your team doesn't do it for me. Your team to me is you, and I would say make sure that the buyer is self-represented.
Okay, and then there's a nuance layer. Should you be selling a TIC interest? Or should your team be selling a TIC interest? Maybe you don't reside in that unit, but your team is handling the sale of a unit in the building where you, a team member, reside?
Oh, that's interesting. So legally speaking, what are you selling? You're selling a 25%, for instance, undivided interest in the entire property, and you happen to own 25% of that property yourself. So the thing that's being sold, technically, you own a portion of it. I would be disclosing that as well.
Okay, thank you.
Nice to see you, by the way. It's been a long time.
Nice to see you too.
Okay, what's next?
Okay, so we'll go back to the question I originally posed to you, and I can't remember anymore. So let's see. Oh, here we go. What happens if only one party initials the arbitration or liquid damages?
Okay,
clause?
so if one party initials and the other does not, and here's how this would come up. The buyer, for instance, would initial arbitration and or liquidated damages. The seller would sign the contract as though they are accepting it, but they don't initial those clauses, okay? This, by the way, is why you want the whole contract, and you don't just want them to send back the signature page, right? You want the whole thing, right? I guess the other thing that could happen would be that the buyer doesn't sign anything. The buyer signs the contract, but they don't initial arbitration or liquidated damages. And the seller, when they send back the contract, the seller initials arbitration and liquidated damages and signs the contract. They don't issue a counteroffer. They instead sign and initial. So now we have mismatched arbitration and liquidated damage initials, right? In both these examples. And my point would be that if we have mismatched anything, then do we have a meeting of the minds? And if we don't have a meeting of the minds on a material term, do we have a contract? So let's say that the buyer made an offer and they didn't fill in the price. And the seller says, yes, I accept, and the seller fills in a price. Do we have a meeting of minds on a material term? I think we'd all say no. Do we have a contract? I think we'd all say no. And so that is exactly the contractual argument for liquidated damages and arbitration. They both are material. They both require initials to be effective. That's a statutory requirement. Only one party has initialed, so we don't actually have a contract. And this happens from time to time, right? San Francisco decided to try to address this. And San Francisco says, we want to err on the side of making deals, not breaking deals. And so if we have a situation where the buyer initials arbitration and liquidated damages, and the seller says yes to the contract, but doesn't also initial, our contract specifically says we have formed a contract, but without those terms. That unfortunately is a bit of a confusing position, and we're updating the contract for next year. We're probably going to take out that special term that doesn't also exist in the car contract, and we're probably going to go back to what everybody else is doing, including car, which is all about a meeting of the minds. Okay? Any questions before we go forward and talk about one other little nuance, the counteroffer? All right, here's the little nuance. This mismatched arbitration or liquidated damage initial problem goes away when a counteroffer is used. Why? Because the counteroffer has a couple of pre-printed provisions that you never noticed, or most of you didn't notice. It has a paragraph 1 and a paragraph 2, and then paragraph 3 is where you start typing your counteroffer terms. And we're always focused on paragraph 3. But what does 1 and 2 say? Well, 1 says when we have items such as arbitration and liquidated damages that require initials by both parties, but both parties haven't initialed, those terms fall out and they're not part of this deal unless they're addressed specifically below. And so when a counteroffer is issued, that takes this mismatch issue away, and we just don't have arbitration or liquidated damages if they weren't both initialed. Any questions on that? All right.
Dan, it looks like we have one from Paul.
Paul, go for it.
Hi, Dan. Thank you very much. My question is directed to the last topic about arbitration. You said something that CAR is going to be wording it. I guess it's a little bit confusing to me because I would imagine that each party has the right to full representation as far as legal representation, and the arbitration clause really doesn't give that person that that choice. So in actuality, they're probably not getting into a contract the way that they'd like to. Can you address that? I don't know if I'm explaining myself correctly.
I think I understand. So let's just do it for a moment. So what is arbitration? Let's start with that. Arbitration is different from mediation. The contract includes a mediation term. Neither party need to initial anything. They're already agreeing to mediation. It's pre-printed into the contract. And mediation is the concept of when one party has a dispute and they'd like to make claims, legal claims against the other, before they file an actual lawsuit, they're gonna seek this concept of mediation, which is like marriage counseling. They're gonna go to a marriage counselor called a mediator. The mediator is gonna listen to both sides and help them come up with a solution that they both agree to. If they can both agree, fantastic. If they can't, the mediator doesn't impose anything. He or she is there just to help. That's mediation. Arbitration is a trial. It's a private trial, however. So instead of filing a lawsuit and having a judge and a jury and bringing a complaint for breach of damages, you file an arbitration claim and you ask an arbitrator, a private person, typically a retired judge, right? Or sometimes a retired real estate attorney. You ask that person with special knowledge in this subject matter or with experience as a judge to hear your claims just like they would in court. You can have depositions and you can have discovery and you have witnesses, but you don't have a judge and a jury. You have an arbitrator who does both. Arbitration only happens in this instance if both parties agree to it, and they specifically have to agree by putting their initials next to this legislative required language. And that's why the arbitration clause is so big, and that's why it requires separate initials, and it has to be in a certain font size, at least 10-point font, and it has to say exactly what it says. And if both parties initial, they both agreed that when one wants to sue the other, that they have agreed instead of a lawsuit with a judge and a jury, they're going to have an arbitrator. And what's the difference? Well, we explained it, but what's the practical impact? The practical impact is that there's nothing to appeal. So if the judge and the jury, in this case, the arbitrator, didn't follow the law, too bad, you're stuck with the decision. But the positive side is that typically the arbitration is a lot faster. You're not stuck with worrying about the court's docket. You just have some person you have to deal with. And so because it's faster, sometimes it's also cheaper because you don't have to spend a lot of money on attorney's fees if it takes 6 months instead of 4 years. But by the way, the arbitrator is probably charging you $1,000 an hour to listen to your case. Okay.
Fantastic. Thank you, Dan.
You're welcome. Okay. I think we answered that. Next one.
Dan, I wanted to ask one question about that. I was told by several brokers that we are not to explain the arbitration clause to them, that we have to ask them to have an attorney explain it to them.
Yeah, I appreciate that, Lori, and I probably should have said that. The risk manager and me should have went there. So with arbitration and liquidated damages, right? If you look at the statewide buyer and seller advisory, they have a brief explanation of both. Both of those have wonderful Q&As that CAR has put together that you can send to your client that explains them. And what you should be telling them is, here's the definition in the statewide buyer and seller advisory. And as it says in the last line there, if you have further questions or concerns, you need to speak with a qualified California real estate attorney. I'm prevented from giving you legal advice, but I do have a Q&A that my California Association of Realtors and their attorneys have put together. It's excellent and it probably answers most of your questions. Let me send you that whole PDF. And if you still have questions, you can go to an attorney. Once you've decided, based on all that information, what you want to do, we're going to confirm it in writing, and then I'll write the contract accordingly. Okay? Okay, I'm going to say good. All right, who's up? Damon?
Sure. What would happen if a client wanted to buy all of the furniture in the house as listed? Furniture's
So,
not.
Damon,
real
out of
property, is
curiosity, have you sold a house and sold the furniture with it?
I have.
Okay. How'd you do it?
Well, we have the real property purchase agreement, and then we have a private agreement between the buyer, which is not part of the real estate transaction, and the seller at an agreed upon price. So they were two different contracts because one is real property versus one being personal property.
What about the lack of trust? And so if it's important to the buyer or the seller that with this deal, they get the furniture or they get rid of the furniture, it seems like it would be difficult for them to say, okay, I'll sign the purchase agreement, but what about the other agreement? Who's going to prepare it? When am I going to sign that? Or are you saying that they got signed at the same time?
It was prepared separately, and an attorney was actually involved in line iteming out the specific pieces that were to be left by the sellers.
Did anybody have a contingency? So I could have seen the contract come with a contingency which says the parties have contemplated the sale of all of the furniture. A separate agreement will be prepared by attorneys. The parties have 5 days to agree on that separate agreement, or either may cancel this agreement.
One didn't precede the other because it was very far along the process of the transaction that the agreement was struck.
Okay, fair enough. But you see, by doing what I just suggested, you could tie them together. But
Correct.
It's also okay to tie them together straight in the purchase contract. Let's look at the next slide. You could have other or additional terms or a counteroffer, which says, for instance, the purchase price is $2 million. For an additional $25,000, buyer purchases all existing furniture separate from the real property and associated fixtures and appliances. Payment shall be made through escrow concurrent with the purchase of the real property. The furniture is included, but the artwork, rugs, dishware, and other personal belongings are not included in this additional sale. Or see attached list of included furniture, or see attached bill of sale form. CAR provides a bill of sale form. Okay, you can sell it with the contract if that's important to the parties. I would be doing it, and you can do it through escrow. You just need to make sure that for a lot of reasons, tax reasons, lender reasons, etc., that you're distinguishing the furniture from the property and the fixtures. And in this example, you have two separate prices, one for each. Both of these things also need to be done in good faith. And let me give you an example of where you could get in trouble in doing this in bad faith. San Francisco has I can't remember if technically it would be regressive or progressive property transfer tax system, but we have this funky deal where at $5 million, the transfer tax is twice what it was at $4.9999 million. And that extra penny cost you about 100 grand. And so you're literally better off when you get an offer for $5 million of countering it for 4.95, you'll make more money. Stupid, but true. So if you're trying to manipulate the sales price by inflating or deflating the cost of furniture, I would say, hold on, go talk to a lawyer, you're scaring me, okay? Right, I'm concerned that you're manipulating the purchase price, that the tax assessor will be looking at all transactions close to the 5 million and the $10 million threshold. And now that we're already in contract, they're going to be asking to see the contract purchase agreement. And now 3 weeks into contract, you want us to amend it to reduce the price to add the furniture. It may raise red flags. Please, I want you to be concerned about that. But if you're doing this in good faith with the initial offer, or the seller wants to sell and includes it in a counteroffer, and you do it this way, it's kosher. Okay? Any questions on that? And if you didn't know that, now you know that. All right, we have one last topic. Jeannie.
What is the intermediate length occupancy, classification, and regulation? All
Okay.
big words there.
Yes. So I'm curious for our 100 participants, have you heard anything about this intermediate length occupancy classification? And I'll give you a hint. Heskin is responsible for this. So our supervisors passed a law a few years ago, right after COVID started in April of 2020, right? Talk about a time to slip in something. And this law changes the concept or the way we deal with certain rentals. And what it deals with is something called an intermediate length occupancy. That is a rental agreement between a landlord and a tenant regarding a residential property that is more than 30 days, but less than a year. This is a new special classification. It's called ILO, intermediate length occupancy, and they decided they're going to regulate them. Let's look at the next slide and we'll talk about how they're going to regulate them. The regulation itself is it's not that it's confusing, it's that it sort of does something and sort of doesn't do anything. But I'll tell you what it does concretely. The first thing that it does concretely is the first thing on this page. All San Francisco lease advertisements moving forward must state the following. You gotta put this in every single online advertisement. So all of those Craigslist ads are all running afoul of this now. They need to say, quote, this unit is subject to the San Francisco Rent Ordinance, which limits evictions without just cause, and which states that any waiver by a tenant of their rights under the rent ordinance is void as contrary to public policy. And so that needs to go in all of your ads. And guess who's going to start to enforce that? The good old people at the rent board. Okay. The good news is they're supposed to send out a warning, right? And they're not supposed to just tag you with fines. And if your question is how much are those fines? I do not know, and I don't think that's actually been established yet. Okay, hold on for that. But what this underscores is this concept of not rent control, but eviction control. If you didn't know, about 5 years ago, the law was changed in San Francisco to make all units subject to eviction control. It used to be that we had huge exceptions for condos and single family homes, right? And then we would talk about, okay, was it built after 1979, before 1979? Is it a condo? Is it a single family home? We don't need that discussion at all for eviction control. That discussion is still relevant for rent control. But in San Francisco, it's all eviction control, meaning that at the end of the fixed term lease, whether it's 1 year, 2 year, or in theory, 30 days, at the end of that fixed term lease, the tenants go month to month, and they can't be removed unless there's just cause to do that. For instance, an owner move and eviction. Not, I want to sell the property and it's a lot more valuable if I get them out, so I want to serve them with a 60-day notice. You can't do that, okay? This whole ILO is intended to underscore the eviction control rights. It says that the purpose of this law is to inform landlords who wish to advertise for an intermediate length, 30 days, but more than 30 days, but less than a year, that they can't advertise that any longer. They can't put out advertisements saying, we're seeking to enter into a lease for that. They can't specifically send to a tenant a lease that says it's for 45 days, it's for 6 months, unless they have a license to do so. At the minimum, they have to give them a 1-year lease. Could they give them a 1-year lease that includes an out that says you can leave early as 6 months and we won't charge you any penalty for leaving early? Yes, they could. Could they advertise it that way? Yes, they could. But unless they have a license, an ILO license, they can't advertise for intermediate length ILO leases, and they can't send out lease agreements that are for more than 30 days, but less than a year. And so what this does is it underscores the idea that even for these intermediate length leases, that there are eviction controls. It's trying to tell people you can't get around it, okay? Now, what do you do if you have an Airbnb that's for 2 months? Technically, you have to tell the people in the Airbnb, I suppose, that they're welcome to stay longer, even for a year if they want. A lot of you would be fine with that because the Airbnb prices are so much higher than a regular lease, right? But this is just one more nuance. But what if you book them back to back to back? So what do you tell the next people when the other people decided to stay? Or this also tells us that we shouldn't be doing corporate rentals, that by renting to an intermediary corporation and then letting the intermediary corporation rent it out to the quote tenant for some 30 days to 1 year, that's violative of this concept, okay? That's what it was also intended to do. So I think the intent of this law was to make sure that everybody who wanted to lease a property for less than a year was made aware that at the end of that fixed term, they could still stay. Right?
And Dan, do we know how many of the 1,000 licenses have been issued?
I don't know that any have. And so that's the next thing. On the right side, we have the information regarding the licenses. It is ridiculously complicated how it is that you get this license and who applies for this license. I'm sorry, and who is eligible for this license. The law says that a maximum of 1,000 of them will be issued, but it also distinguishes where they're issued. Some neighborhoods can issue more than others. The qualifications for the licenses are onerous and confusing. 3 or less unit buildings are exempt, can't get one, that's what that means. Rent control properties are exempt, can't get one. A maximum of 20% of the units in any one building could get a license. So if you own a building with a number of units in it, right, you could get one for a few, but not for all of yours, right? It's all over the place. So I think the takeaway here is if you're playing in this world where you're trying to rent 30 days to 1 year, you're going to need to make sure that the price is such that if they stay, you're happy, because they probably have the right to stay. You're probably prevented from telling them that this is something less than 1 year, but what you can advertise, right, to encourage these things, and what you can include in your lease is something that says you can leave after 60 days if you so want, and I won't penalize you. Okay, I know that one's confusing, but that's not my fault. That is our supervisors in action.
Hey, Dan, we just had a question pop up in the chat. Can a resident apply for a license without the owner knowing?
So the license is for the owner, the landlord, to be able to draw up a lease that says this, or to advertise something that says this. I think in theory that since the owner couldn't do that, if there is a tenant who doesn't wish to be there for a year, the tenant could sign a 1-year lease, but make sure that it includes a provision allowing them to leave after 45 days without any penalties, right? I think that's the solution.
So the majority of us are probably going to be doing, I mean, if you're in rentals and commercial rentals, you're in, but the majority of us maybe will have a single family home. Our clients, need to rent out. We want to help them out. So we would put this in their advertising.
Yeah, so the first thing is in the advertising, you have to have this little statement here. This unit is subject to San Francisco rent ordinance, et cetera, in all advertising, right? That's the first place we're going to screw it up, right? Is not have that. And the next place we're going to screw it up is we're going to go out and try to find short-term rentals and advertise as such, right? Or draw up leases that are for less than a year. I don't think we can do that anymore. This, by the way, Jeannie, it just underscores why leasing experts should be leasing experts and sales experts should be sales experts. And you're not doing your client or yourself a favor when you're trying to do both. You really aren't.
Okay,
All right.
We do have time for a question that was non-related to your slides. Let's see here. So from Eileen Mitchell, what happens if an agent from a different brokerage gets hurt at my open house? Whose brokerage is responsible? Is this something to worry about?
Well, I would think that this is something to worry about. And I would, by the way, this is a great reason that you should never, ever let another broker run your open house for you, right? And so if you're in a small brokerage and you can't do an open house on Saturday, you're tempted to say, okay, Dan, could you cover for me? If Dan is with another broker, it's a very bad idea. It's probably true that your company and or the seller's insurance between the two of them will cover somebody's injuries at an open house. I have been an agent with clients who went to an open house and their child literally fell out the window. There was a lawsuit. I testified. Fortunately, there was insurance. The insurance that was being used was both the brokerage's insurance and the homeowner's policy. They could have, in theory, sued me also as their agent if they thought that I somehow breached my duty. Would have been a much harder case. I would be concerned, however, if we had this mixed match of brokerages. You should be asking your broker what your E&O coverage does. Is it only professional responsibility for giving bad advice, or does it in any way include personal injury? It depends on the policy. It's likely that the homeowner's policy is the thing that's going to be deciding here. And if you look at the listing agreement itself has a discussion about the seller indemnifying the broker and under what circumstances.
I think we've ran out of time. We do have a few questions that Emily will save and send over to Dan to answer. But we are out of time.
Cool. So let me ask you this. When are we going to do this again?
September
the 1st.
Yes. Is it?
Oh, Oh, actually, so
September
September,
5th.
say it again.